Good afternoon, welcome to Policy Exchange, and always a pleasure to be able to welcome back the independent reviewer of terrorism legislation of state threats. Many of you will have been here for Jonathan Hall's last address here, the Creaney Memorial Lecture last year, but so many tragic and important events in the intervening period, we felt it vital to bring him back. He kindly agreed to do so at short notice. Lessons of Bondi Beach and much else besides, in both his capacities as independent reviewer on terrorism legislation and state threats. As indicated, he's going to deliver his address here, then answer questions. So usual house rules, no question too outrageous. You just have to state your name and organisation first. Jonathan, thank you for your friendship through the years. Look forward to hearing what you have to say. Thank you.
Thank you very much, Dean. Thank you, Policy Exchange. After the murders at Bondi Beach, attention is being given to the meaning of globalise the Intifada, death to the IDF, from the river to the sea, and similar chants used by anti-Israel demonstrators. The precautionary principle, a central feature of national security law, suggests that this renewed attention is well merited. The precautionary principle was described by our own Supreme Court last year as preventative, about deciding to act rather than waiting until directly harmful, or in the case of attacks against Jews, even more directly harmful activities have taken place. The current targeting of Jews for murder coincides with 2 years' worth of public calls for death, if those calls are read literally. The parallel with Abu Hamza's calls for jihad and martyrdom outside Finsbury Park Mosque over 2 decades ago is chilling. You will remember that Abu Hamza, the so-called hook-handed cleric and former imam of that mosque, preached that it was acceptable to kill non-Muslims, kafar, and necessary to go after the blood of Jews. His public words should have been understood much sooner as a genuine call to deadly action. Now, immediately after Hamas's deadly attacks on the 7th of October of 2023, many, like me, were willing to apply a different sort of precautionary principle. We believed that free speech and the right of protest were too important to curtail, despite the occasional disorder, rabid hostility, and sheer inconvenience of the repeated marches. The protesters should be taken at their word. They were drawing attention to the Palestinian cause and instances of real suffering, and their noisy, disruptive protests were a necessary feature of democratic life. They could not be written off merely as hate marches. In a paper that I published in November 2023 called Terrorism and Protests, I responded against the pressure then emanating from within the government to extend terrorism laws. I concluded there was no need to add to or amend terrorism legislation, and good reason for caution. I added there may well be other mischiefs arising from the marches, such as anti-Semitism, but those were not a subject for terrorism legislation. Even the fact that the marches started suspiciously soon after the Hamas attack and have continued after the Trump brokered ceasefire do not and should not call the principle of free speech and free protest into question. But any precautionary principle is provisional and capable of responding to evidence. The first evidence has suggested to me that this was not always protest, or not protest worth protecting, came in the persistent invocation of the red triangle, the symbol used in Hamas propaganda to show physical targeting of Israelis in the combat zone. This was a direct support for violence, and others will have equally valid alternative examples, such as the cry, death to the IDF, or the call to globalise the Intifada. No longer were these demonstrations polluted by the odd individual reference to Hamas, but they were steered deliberately near places of Jewish life. The dial moved again when pro-Palestine protests were conducted at Liverpool Street Station in London hours after the Heaton Park synagogue attack in October. By breaking the convention that any terrorist attack on British soil is a time for solidarity and mutual support, the protesters' views must have been that the Heaton Park murders were just further deaths compared to, for example, they would say, the death and suffering in Gaza. Terrorist deaths in the UK were thereby being normalised. In fact, it sometimes seems to me that it's not so much extremism as normalisation that we have to fear. If sectarian calls to violence are normalised, then the risk to national security is too great, and the first precautionary principle of national security comes into play. The risk of allowing the public sphere to be infected by sectarian calls for violence is palpable, and it's well understood from our own history that domestic and international terrorism have been inspired by mere words, as the cases of Abu Hamza and Anjem Choudhury and al-Muhajirun clearly show. It will be recalled that al-Muhajirun, notoriously in their 2010 Remembrance Day protest, called for British soldiers to burn in hell. They were seeking to move the dial about the acceptability of violence, and in too many cases their rhetoric succeeded. Who can forget the murder of Fusilier Lee Rigby on the streets of London by followers of al-Muhajirun? In the next parts of this lecture, I consider firstly the relevance of hate speech to terrorism. Secondly, I observe that conventions concerning collective hostility on the basis of race or nationality have been ignored in the case of Jews and Israelis. Thirdly, and finally, I suggest what the law can do about it. So a core feature of UK counter-terrorism practice is disruption of mounting risk by any lawful means. To take a hypothetical example, it may be effective to stop a car carrying a suspected terrorist for a traffic violation where the grounds of suspicion are based on sensitive intelligence. Another way of saying this is that we don't exclusively rely on terrorism legislation to preserve national security. I remain of the view that terrorism legislation is unlikely to be the solution in the great majority of protest-related cases. Indeed, the late Professor Conor Gearty was of the view that terrorism laws were so exceptional as to be illegitimate, that they so perverted the ordinary principles of criminal and administrative law that they should be abolished in their entirety. Well, I don't agree with this view, but there are two related principles of some relevance to the marches. Firstly, terrorism legislation should be used as little as possible, and only where ordinary law is insufficient to deal with the threat. Secondly, the need to use terrorism legislation can be kept at bay if ordinary laws are properly enforced. What I mean is that if laws and standards are disregarded, so a situation conducive to terrorism arises, it's more likely that terrorism laws will one day be needed. If the law fails to intervene when protesters openly call for death, if strong and regular and violent hatred becomes the norm, then violence, terrorist violence, even genocidal violence, as in Rwanda and Myanmar, is a plausible consequence. Hatred is distinct from terrorism, but it raises the risk. It invites a state of psychological extremism in which conspiracies make sense and violence seems the only solution. Support for this proposition is not hard to find at a level of principle. In 2014, the then UN Special Rapporteur on minority issues, Rita Itzhak, said, quotes, "Hate speech in public spheres, in mainstream and social media, and by influential groups, including religious leaders, public officials, or political groups, can lead directly or indirectly to violence against minorities. Increasing levels of hate speech can be an important indicator of possible violence." In 2021, her successor, Fernanda Varenne, observed that, quotes, "Dehumanizing language, even reducing minorities to pests, normalizes violence against them and makes their persecution and eventual elimination acceptable." And in June 2025, Antonio Guterres, the UN Secretary General, said, quotes, "Hate speech is poison in the well of society. It has paved the way for violence and atrocities during the darkest chapters of human history." Now, of course, individual states will have different ways of minimizing hate speech. Sometimes it will require the use of the general criminal law below the level of terrorism legislation, or the placing of restrictions about what can be said in the public domain. And we can question whether individual instances of hate speech will in fact lead to individual acts of violence. It is true, I concede, that most people who hear violent chants will reject them. But doing nothing is not an option, especially where hate becomes normalised. There is another set of international experts that we can, and I suggest we should, learn from, the terrorists themselves. Terrorists spend much time and effort in disseminating hateful material to encourage attacks against the West or against its chosen targets, be they Jews, Christians, Ahmadis, or whomever. Jihadists and extreme white terrorists have whole apparatus dedicated to producing terrorist propaganda and then broadcasting it. They often do this online, using what analysts describe as beacon sites, aggregators, and content stores. They believe that propaganda works, and it does. At some stage, the Heaton Park killer and the Bondi Beach killers must have encountered Islamic State propaganda and decided that they were soldiers called to carry out violence in support of their hateful agenda. And what do we find when we consider Islamic State's online propaganda? Now, on the 18th of December 2025, Islamic State published an edition of their official magazine Al-Naba in the days after the Bondi massacre. Having, as you would expect, celebrated the attack, it said this, quotes, "Even though the Islamic State has not yet had the circumstances to clash with the Jews, the attempts of its soldiers, delegations and supporters, that is, the soldiers, delegations and supporters of Islamic State, have not stopped planning to strike the Jews everywhere in a fierce, invisible war between the soldiers of the Caliphate and the global intelligence agencies harnessed to protect the Jews." This online rhetoric vindicates the view expressed by analysts such as US official Seb Gorka that anti-Semitic hate speech is central to the jihadists' cosmic war narratives and is used as a grievance to recruit, radicalise and inspire violence. The simple point to ask is, if this narrative is damaging online, why would we allow it onto our streets? Islamic State must be rubbing their hands when they hear death to the IDF, globalise the Intifada, and see the red triangles of death presented with the directness and proximity of street protest. In short, terrorism and hate are distinct, but often symbiotic. Mere hatred often lacks the political, religious, racial or ideological cause which is needed for terrorism, but hatred can be harnessed by the terrorist for his grander purpose. Now, in my line of work, it is essential to draw a distinction between individual terrorists and groups. Muslims are not to blame for terrorist attacks by individual Muslims. The fact that many, perhaps up to a third, of children arrested as extreme right-wing terrorists, the fact that they, in a third of cases, have autism, does not mean that autistic people are suspect. This also applies to my other line of work, state threats, where I've cautioned on the need to use powerful national security laws carefully to avoid the impression that individuals are being targeted because of their nationality or family background. In other words, the evils of Putin's regime do not believe that we hate Russians. We distinguish between the people of Iran and the Ayatollahs. The Chinese people are not the Chinese Communist Party. There is a long-standing distinction between governments and states and the people, which reflects common humanity. This care to distinguish between individuals and groups is a strong feature of academic studies on terrorism, so much so that anxiety is expressed over potentially ambiguous terms in common use. It's frequently argued, for example, that the official term Islamist extremist terrorism unfairly implicates Islam and therefore all Muslims. For similar reasons, there is a proposal under active consideration in Australia, or at least there was before the Bondi attack, to remove the phrase religious cause from their definition of terrorism, lest it be used to stigmatise religions in general and Islam in particular. Care is taken about groups. A key paradigm of modern terrorism studies is that counterterrorism risks creating, quotes, suspect communities. Human rights-informed literature is therefore replete with the desire to avoid stigmatising by an incautious use of language, to avoid negative stereotypes or tropes, and the need to bring a sensitive ear to pick up any trace of othering minorities or of disguised racial insults. In this vein, and in the wake of Bondi, the current UN Rapporteur on Terrorism, Professor Ben Saul, has called on authorities to ensure that Muslim Australians and migrant communities are not stigmatised in debate. This care is also apparent in political discourse, and as far as I'm aware, protests by Jews, by pro-Israeli supporters in the UK. But there is an exception to this rule. When it comes to demonstrations against Israel, we witness a delight in words that spread hatred incautiously. Hatred expressed to Zionists invites hostility to every Israeli and to Jews worldwide. Contrary to all good practice, Zionist is a term that invites stigma and othering. Even if the term is ambiguous, as its defenders might say, I've seen no caution expressed about this term by those who use it, or fears that Jews are becoming, in the jargon, a suspect community. Those who use this term resort to technicalities. Look, there are some Jews who are not Zionists, and overlook the rest. The silence from swathes of academia and from international rapporteur about the risks of stigmatizing Israelis and Jews is deafening. Alongside a marked reluctance to avoid prejudice to Jews in the use of language has been a refusal to consider the targets of hatred as bearers of individual rights. It is well established, for example, that convicted terrorists have rights against physical mistreatment. Attributing rights to terrorists is a way of testing whether rights are truly universal. But this consideration appears wholly absent, even on the part of many who like to be described as human rights defenders. The possibility that destroying Israel will result in the deaths of individual citizens is neither acknowledged nor regretted. And this brings me to the recent arrival of Alaa Abd al-Fattah. It seems to me that we have much to learn from Mr. al-Fattah. One genuine service that he could perform for his fellow Brits is to explain why human rights defending like his went hand in hand with the most hateful, violent rhetoric. Was it necessary for Mr. al-Fattah to write these things in order to prove his credential with his peers? Is this type of hatred so endemic in Egyptian or Middle Eastern society that he didn't pause for thought about the targets of his hatred, or see his targets as individual human beings? And I would ask the same questions of the marchers who hold or march alongside or tolerate banners of hatred towards Zionists. I would hope the answer would be more than, well, of course you'll be full of hatred and anger if your people were being exterminated or oppressed. I genuinely wish to know why it is that some protests on Israel and Gaza appear to be inseparable from violent hatred of people. But whatever their explanation might be, it seems to me the law will have to intervene to reduce the risk of real-world violence. To summarise my argument so far, terrorism legislation should be used as sparingly as possible against protesters. Anti-Semitic hatred is real, and as Bondi shows, can have real-world consequences, engaging the precautionary principle. Despite this risk, the importance of not stigmatising groups of people has not been applied equally. And although it's interesting to speculate why this might be the case, allowing hatred to be normalised is not an option. So I now finally turn to what the law might do about it. It's often the case that there's no need for new laws. It's simply that existing laws are not being properly enforced. There's no need to reach for terrorism legislation if existing non-terror laws are properly understood and brought to bear. Let us look in more detail at some of the tactics that have emerged on the part of anti-Israel protesters and consider the implications. The well-documented removal of pictures of Israeli hostages and the trashing of 7th of October memorials are consistent with only one thing, that Israeli feelings are illegitimate and therefore they uniquely cannot be allowed to show grief or commemorate suffering. For some, any signs of Israeli life are illegitimate. There have been protests against Israeli-owned restaurants and bakeries in London and Australia and the United States. In Australia, a restaurant with Israeli ownership was attacked by protesters shouting "Death to the IDF," and we all seen the recent protests against the Israeli-owned restaurant in Notting Hill. Why does it matter if Israelis are demonised and become objects of legitimate hatred? Firstly, it matters because Israelis are a group like any other, whose individual members, like members of any other group, deserve protection. We've lost our collective sense if, as a society, we permit the demonising of holders of any nationality who live in our tolerant and open society. The basis of our liberal society is one of individual flourishing, not collective punishment. Either we believe in individualism, not tribalism, or we don't. I would say the same if the targets of public hostility were Russians, Chinese, or Pakistanis, or Somalis. And it frankly cannot be comfortable as a person of a different nationality or heritage to wonder when the torch of collective hatred is going to be pointed at you next. Secondly, the demonisation of Israelis matters because it is a vehicle for hatred of Jews. My perception is that if you don't deal with anti-Israeli hatred, you leave wiggle room for those who indulge in anti-Semitism but formally disavow it. Once hatred to Israelis is tolerated, then it's carried around like a flame. In the UK, we've seen attacks on Marks and Spencer's stores, including the stabbing of customers because of supposed links to Israel, protests against a Jewish community centre hosting Israelis discussing the Gaza conflict, and protests directed at a synagogue because there was a talk about emigration to Israel. This is targeting on a human level. And the truth is that hatred of nationality fits onto hatred of race like a glove. And importantly, our law recognises this. The Public Order Act 1986 prohibits stirring up racial hatred. Let me read Section 17 of the 1986 Act, which defines racial hatred, and I'm going to do this deliberately slowly. In this part, racial hatred means hatred against a group of persons defined by reference to colour, race, nationality, including citizenship, or ethnic or national origins. I have lost count of the times that hatred against Israelis has been stirred up on British streets. I do not believe the law is being enforced as it should be. If, according to intelligence held by West Midlands Police, local Islamists were arming themselves and preparing to seek out and attack fans of Maccabi Tel Aviv, that can only have been because of their hatred to Israelis. The local Islamists were not hostile because of football, they were hostile because of nationality. As we speak, Lord Ken MacDonald is carrying out a review on public order and hate crime legislation. For my part, I think the offence of stirring up racial hatred, including on the grounds of nationality or citizenship, is a vital precursor offence to deal with some of the public hatred we've seen on our streets before it leads to violence or even terrorist violence. I do not want myself or my successor to be wrestling with the possible extension to terrorism legislation when the law is already there. The counter-arguments to laws against stirring up hatred on the grounds of nationality are easily stated and, I believe, easily dismissed. Firstly, it could be argued that stirring up racial hatred is too vague. On the contrary, I think the words of the offence are clear terms in ordinary use. They refer to racial hatred, not vague eye of the beholder hostility. Secondly, that the offence inhibits free speech to an excessive degree. It is true the offence would curb someone's ability to carry placards saying, "Clean the world of Zionists," or some such, but this is hardly an illegitimate restriction, and in any event, every prosecution requires the consent of the Attorney General. I also think we need to recognise that rights cannot be asserted in order to subvert other rights. Even the sometime maligned European Convention on Human Rights specifies in Article 17 that nothing in the Convention implies for any state, group or person any right to engage in any activity or perform any act aimed at the destruction of any of the rights and freedoms of others. In other words, democracy should not harbour the seeds of its own destruction. Thirdly, it might be said that prosecutions are too difficult. It is true that the recent prosecution of individuals shouting "Khyber, Khyber, Ya Yehud" for stirring up racial hatred led to an acquittal, despite the obvious anti-Semitism of that notorious phrase. I do not know the precise facts, but criminal lawyers amongst us will be well familiar with prosecutions that became easier over time as expert evidence was developed and better explanations were given to juries. I would also consider a link between the risk of stirring up racial hatred and the licensing or banning of marches. One of the striking features of pro-Palestine marches is the repetition of hatred without check by other marchers. For example, on the 18th of May 2025, a protester held up a sign saying, quotes, "The Western Zionist puppet masters instruct their evil scum puppets in Tel Aviv to do their dirty work," quotes. No one, it seems, bats an eyelid. It should be possible for marches to be held against Israel's actions in Gaza without hatred, but the scorecard in avoiding hatred is not good. Serious disorder cannot be the only basis for restricting marches. The alternative is higher and higher walls, a suspect community of Jews, relying on volunteers and receiving government grants to strengthen security. And indeed, a wider society retreating behind bollards, anti-vehicle architecture, tied up in counter-terrorism red tape such as Martin's Law, the Terrorism Protection of Premises Act 2025, which, when it comes into force, will impose obligations on almost 200,000 businesses and charities at a cost of £207 million per year. I mentioned before that terrorism legislation is exceptional. It requires the surgeon's scalpel to deal with the bad guys, not a bludgeon to spread the pain. There are laws to deal with terrorism, and there are laws to deal with hatred. Let them be used wisely but effectively. Thank you.
I imagine there'll be many takers there in the audience. Can I just get a sense of who wants to ask a question? Let's see, 3 in the front row. Gentleman on the far left at the front, please. Far left to me, far right to others, perhaps. Yes, microphones, please. Yes, yep. Yeah. Just say name and organisation, please.
Hello, my name's Paddy McGuinness. I work for Brunswick Group, but I was Deputy National Security Advisor. And I was very taken with your framing, taking us back to Abu Hamza and to Lee Rigby. And if I may, I recall with Lee Rigby, we concluded, I think a parliamentary committee concluded, that the people who might have stopped it were Facebook, who had access to data where the act was being planned by these individuals, but it wasn't. And I just wonder about the online space in terms of hatred, because I am struck by the difference between what I experienced then in office, so to speak, and what I see now when I look at, pardon me, TikTok, and I see the way in which everything you describe in terms of hatred is amplified and repeated, and there is a battle online about hatred in our community online. So what about the online space?
I think that the question of how to regulate the online space is the most urgent question of our day, frankly. I also think it's the most difficult question of our day. I think that the way that the debate is even talked about, with ministers, the Prime Minister saying we're going to ban X, or it's the safest place to be online, are wrong, because very few people understand the limitations to what we as the UK could do. And that includes expressly what you can do about X and their new defining features. So when it comes to hatred online, I don't candidly know the answer. The only thing that I've managed, and I've looked at this in a lot of depth, I think the only thing I've reached the conclusion is that children should be offline, not on, because their brains are not capable of dealing with this hatred. But we're obviously talking about adults who are also influenced by this hatred. So I think that I'm going to say I don't know is the answer, but what I think I do know is that there is a proximity to street protest. There is a licensing which comes when you see a fellow person on the street saying something, which is different from some anonymous avatar expressing hatred online. So I think they're different, and we've got to start somewhere. I don't know the answer to the online conundrum.
Gentleman there. Name and organisation, please.
Lord Borwick, member of the House of Lords. I read somewhere that the Bondi Beach perpetrators had been trained or had visited the Philippines. Is the Philippines becoming a center of Islamic terrorism as it perhaps was in the Spanish-American War?
I candidly don't know the answer. So rather than trying to flannel, I don't know.
Just see several questions online. David Barrett, Daily Mail. Can you hear me? David? Is it working?
Yes, I'm here. Can you hear me?
Loud and clear. Please, your question.
Thank you so much. I was hoping to ask an initial question about your presentation, Mr. Hall. You said that the law is not currently being enforced as it should be. Who is responsible for that? Is it the police forces, or is the responsibility more wide than that? And secondly, you will have seen today that Abu Zubaydah, the Guantanamo detainee, has been awarded a substantial payout. The circumstances of that payout are not yet clear. He's a recent client of the Attorney General, Lord Hermer. What issues does that case raise in terms of the propriety of such a payment and potential for legal confliction within the government, please?
I mean, I'll deal with the second question first. I mean, when I was practicing the bar, I used to delve in these sorts of areas on behalf of, I represented MI6 at one stage, who were accused of all sorts of things. One of the key things that you probably is not widely recognised, a lot of these cases come down to the question of disclosure and the cost and pain to the government in terms of being potentially forced to disclose information potentially about American allies, which means that settling these cases is quite attractive. I don't know any more about the facts, apart from the fact it does appear to be clear, as the Americans have conceded, that he was tortured. Whether that should result in payment by the government for complicity, which is the way in which it's generally put, I don't know. On the first question, which is enforcement, I think enforcement of laws is more important than the laws themselves, and the people responsible for enforcing the laws are the police. Ultimately, police have got to be responsible for the safety of their citizens, and I include expressly within that Israeli citizens, as well as Jews living amongst them. They are the ones who are going to have to take the legal risk on this. They will be advised by the CPS, sometimes, as we know from the Axel Ruda-Cabana case, where the CPS came out with very, very cautious advice about what could be said about the identity of Axel Ruda-Cabana. Sometimes we know they'll be overcautious. So I think I would encourage the police to think about their number one obligation, which is to keep the peace, put the resources in there, and use the laws that are available. But ultimately, it comes down to the police, I'm afraid, no one else.
I see one other question. Jerry Scott from The Times. Jerry, can you hear me?
Hello, can you hear me?
Yes, loud and clear. Please, your question.
Hello, I'm actually Daisy Eastlake from The Times. My question is, do you think the Islamic Revolutionary Guard Corps should be prescribed as a terror organisation? Thank you.
The answer is, my concern, and I wrote, as you know, a report on this, is that we don't go round this plug hole every 6 months to a year, by which I mean an issue involving the Revolutionary Guard Corps comes to light. Now it's in the context of the repression in Iran and the protests. In 6 months' time, assuming the regime doesn't fall, it'll be because of some sort of transnational repression or assassination of an Iran TV journalist in London. The key thing, and this was the whole point of my report, is the government has to create the options for itself. And at the moment, my own assessment is terrorism legislation doesn't apply to state bodies, which is why I recommended they created a new tool. I think one of the sort of impoverishing aspects of this debate is that there are two things that work. One is, should they do it? And secondly, should they have the tools? And I think the answer to the second question is, of course they should have the tools, and it's a matter for government. Obviously, they've got a legislative agenda. It's a matter for government to work out whether they want to legislate to create the tools, and then they can be held to account for not using it.
The other lady there in the second row. Name and organisation, please.
Hi, Latika Burke from the Nightly Australia. I was actually in Australia during the time of this attack. Two questions. One is, I just want to hear from you very clearly. You said before that the protest marches are symbiotic with terrorism. There is an argument in Australia that is raging that actually these guys were inspired by ISIS, so there's nothing to do with the marches. Are you saying that they are and can be and should be treated as directly related? And secondly, just back to this question, one of the things that we saw after the Bondi attack was this AI image of one of the victims that went around pretending he was being staged. At what point does content like that come under law? Is it terrorism law? Is it misinformation? It seems to me that that's a big gap, and it is an attack of some sort. Where does terrorism legislation fit in for that sort of an incident?
Yeah. I mean, on the first question, it is almost impossible to draw a direct link between particular speech and an attack. Sometimes, I mean, if I see terrorism material, I'm not going to be inspired to go and do something. And I think that when you make policy about regulating speech, I think you have to have that sort of humility in mind. I talked about the precautionary principle deliberately because we've now seen in the UK 3 sets of attacks, completed terrorist attacks involving Gaza. And we know, as I mentioned from our history in Al-Muhajirun and Abu Hamza, that what is said on the streets can have an impact. So I think that's where the precautionary principle comes into play. I don't know whether or not those individuals who were linked to Bondi, who carried out the Bondi attack, I don't mean linked to, were the murderers, whether they were inspired by Gaza, but it seems so plausible that I don't think we should take the risk again. On the second question, which is misinformation, I think that this is one of the worst words, misinformation, disinformation, one of the worst words that one can use. It is obviously the case that lies can be used to tell a bigger truth. And the example I always think about is the Trojan horse affair. And if you followed English politics, you'll know that there was a letter which turned out to be a fake, which revealed a true plot amongst Islamists in, I think, Birmingham, to take control of education and schools. The problem about saying that things should be banned because they're untrue is because what is true and the truth value of certain statements is often quite hard to detect. I mean, there is law in the UK which is not terrorism law. There is law under the National Security Act, but it only applies if you can attribute it to the work of a state. So if the Chinese or the Russians or whoever were coordinating what they call inauthentic behaviour to try and drive a fake narrative, in principle you could try and arrest and prosecute those people. But I'm cautious about the word misinformation, I have to say.
Good. I'm just looking towards the back. Did I see anyone with their hand up? Yes, gentleman at the very back. Thank you, in the blue jacket. Name and organisation, please.
Thank you. David Maddox from The Independent. A couple of questions. First of all, you used the word suspicious regarding the timing of the Liverpool Street station protests and the Heaton Park murders. Do you think there is a potential link between these protests and some of these terrorist acts beyond the language that's been used on protests? And do you think that the police should be looking again at licensing of these protests? And second of all, on the Iranian question, on the IRGC question, do you think the government need to prioritise getting these tools in place? Because obviously your review was some time ago.
Yeah. I mean, on Liverpool Street Station, I mean, having operated in the sort of terrorism world as I have for many years, I'm sort of conscious of a sort of playbook. And I mean, it was one I think was perfected by Tony Blair, but probably before then as well. You have a terrorism attack. The Prime Minister or whoever comes out and articulates the feeling of the nation, which is we are not going to allow terrorists to divide us. We will carry on with our normal lives as before. And that expresses the view of the nation. What really struck me about the Liverpool Street demonstration is that was two fingers to that long-cherished understanding that we stand together as a nation against terrorist attacks, which is why I found it so shocking and appalling, actually. I do think the police should both use the tools that are available to them in terms of looking at what they can currently do to prohibit marches if there is a risk of anti-Semitism and hatred. I also think that in due course the law will need to change. As I say, the principle is the risk of serious disorder. I think the principle should also be the risk of stirring up racial hatred. On the Iranian question, should they prioritise it? Don't know. That's a political matter. I mean, they've got lots of things on their plate. All I can say is that the debate will end up, as I say, going round the drain until someone puts legislation on the statute book.
Question online. Professor Clive Walker, Professor Emeritus at Leeds, I think author of distinguished volumes on terrorism legislation. Professor Walker, can you hear me?
Hello, yes, I can. Can you hear me?
Yes, loud and clear. Please go ahead.
Okay, hello, Jonathan.
Hi,
my question is whether there might be pressure or value in extending the existing public order legislation in ways parallel to which you have proposed to extend the state threats legislation as currently embodied in the National Security Act. In this way, should the law be extended to ban individual speakers or groups from public protest without proof of an offence, or in some cases after proof of an offence? Or alternatively, is the power to bind over a forgotten a friend which should be more prevalent? It has made an appearance a long time ago in Canada and is occasionally used for protests related to terrorism. Thank you.
Yeah, thank you. Clive is also my special advisor, so he knows where my weak spots are. So, I mean, Clive, I'm pretty cautious about what they're doing in Australia. So right now, the Australian federal government is bringing forward legislation to ban hate groups. I think the difficulty that we have, and I will carry on articulating this difficulty, is the principle of threat neutrality in this country is a really important one, which means that if you want to try and frame a law against terrorism or a law against extremism, you've got to do it in general terms. Every attempt to try and identify a sort of general idea of what extremism is tends to lead to failure. It may be that one's got particular groups in mind, for example, an Islamist group, but that will look very different from another sort of group. And I mean, the attempts that have been made end up, in effect, saying that if you want to bring down parliamentary democracy, which involves campaigning against the House of Lords, you are, quotes, an extremist. So I'm pretty sceptical about that, but I've got my eye on Australia and I'll see how that goes. I tend to think that what is lacking is not law but resolve. And one of the things I found slightly frustrating about some of the commentary from leading police officers is the complaint that they don't have enough law, when I actually think the question is, do they have enough resolve to use the law? In terms of bindovers, I mean, that fits with my general principle, which is let's use the law as we've currently got it. So it's a good idea. Thank you.
Gentleman there on the far side of the front. Name and organisation, please. Sorry if you just wait for the microphone so we can hear you.
Thank you. Tim Diat from Christian Concern. What do you think the police should do about anti-Semitic hatred being preached in a mosque, for example, point one? And point two, what about this case that we read about today of a Labour MP who was barred from a school because of the threat of protest, which is kind of a heckler's veto? What should the police or the law do about that?
I've probably got more expertise on the first and the second, but if a imam is stirring up racial hatred in a mosque, they should be investigated and prosecuted. I think it's simple as that. In terms of schools, I mean, this seemed to be the most appalling example of someone where he was Jewish, he is married to an Israeli, and the protesters or the demonstrators or the officials or the unions were saying, we're dancing on a pinhead, and trying to say, in effect, well, it's not about that, it's about that. And I just go back to what I said in the third part of my report. Human rights organisations, unions, people with principles spend a lot of time, quite rightly, trying not to make groups of people suspect. But that seems to have completely gone out of the window. And no one seems to have said to themselves, might this look anti-Semitic? Might this look anti-Israeli? Can we afford to risk someone with different views to our own because of the consequences of driving an MP away from schools in his own constituency?
Thank you. Lady there, name and organisation, please. No, in front of you.
Sorry, Barnes Foster, House of Lords. Part of the difficulty you mentioned was the normalisation of terrorism, and of course in Northern Ireland we had the acceptable level of violence, which you might remember that awful phrase that we had. Nowadays what concerns me is the narrative that is growing up around glorification of terrorism, and that the IRA and others are being made to look like a cool bunch of lads who did great things. So I know you've said that the law is there and should be used to deal with glorification of terrorism. However, do you not think that the glorification of terrorism piece in the Public Order Act is too tight? Because you have to actually want the person to emulate. There has to be an intention to emulate the terrorism. Whereas I think what's happening at the moment is that there's a narrative growing up to go to your hate speech piece.
Yeah. I mean, I think you're talking about section 12 of the Terrorism Act, which makes it an offence to make a supportive opinion towards a terrorist group where you know or are reckless that someone will thereby be encouraged to emulate it. I mean, the only answer I can give is please look at the report I did on terrorism and protests. I looked quite closely, because there was pressure within government, to consider removing the intent to emulate aspect from it. It throws up all sorts of weird false positives. I mean, for example, if I praise Nelson Mandela, who of course was a terrorist, then I commit an offence. There were two, if I talk about historical events, and I mean, particularly in the Northern Irish context, I think people, you won't forget, but people won't necessarily know, the question of history is so contested, and reaching back into history is such an important part of the glorification you're talking about. So, I mean, I had a look at it, but ultimately I couldn't achieve a terrorism offence. I mean, I think all I would give you is this. If you were going to do that, I would try and take it outside the zone of terrorism legislation. I mean, there may be a case for glorification in the context of the Public Order Act, but I don't think there's a case for making someone a terrorist merely because they have praised someone who was at one stage a terrorist.
I see online Rajiv Sile, Home Affairs Editor, The Guardian. Rajiv, can you hear me? Can you hear me? Third attempt. Can you hear me?
I can hear you. Can you hear me?
Yeah, go ahead.
Yeah.
Third time.
Hello. Yes, thank you. I just wanted to ask about the fact that, Jonathan, you supported obviously the ban on Palestine action, and now we're seeing the possibility of hunger strikers dying. Are you concerned about the effects of hunger strikes on support for banned organisations such as Palestine Action, and particularly when we think about what happened in Northern Ireland post the hunger strikes there? Thank you.
It's a good question, but ask me when the criminal proceedings are no longer live.
I'm looking just to get a flavour in the remaining time, just to see who wants to ask. Gentleman in the front row. Yes, please, just if you could say your name and organisation, please.
Thank you. Thomas Harding from The National. Just on your good speech, are you making the point that anyone who has a red triangle or says death to the IDF or globalise the Intifada, that the police should use the Public Order Act to go in there and arrest them? As a first question. And the second one, do you have any concerns over the current situation in Iran that Iranian operatives in the UK might be used to get up to their mischief that they have done before?
Yes and yes.
Others, please. Any other question? Do I see any other hands? Gentleman there on the far side. I see a hand, I think. Sorry, and my eyes are slightly dazed by the light, but there's... Name and organisation, please.
Yes, thank you. Andrew Tillett from the Australian Financial Review. And I know that part of Sydney very well, where it happened last month. If we accept that the protests have gone too far with anti-Semitism and there's an outright Jew hatred on our streets, both here and in Sydney and Melbourne, how, though, do we go back to a point where there can be legitimate protest or complaint against the actions of the Israeli government without veering into this sort of hatred? What are the sort of the parameters around, perhaps, especially when we've got our governments both here in the UK and in Australia, which are critical of the Israeli government from time to time?
I think the answer is very simple. Just protest about Israel's actions in Gaza and don't incite hatred against Israelis or Jews. I mean, in fact, of all the sort of thoughts I've had, this is the one I find least difficult to deal with. It's quite clear, isn't it, that you can have protests and marches without inciting hatred. And I just think that no one should ever fall for, I know that you're not articulating it, you're just exploring it, but no one should ever fall for the totally bankrupt argument that if you squash inciting hatred, it becomes impossible to demonstrate. Of course it is.
Online questions, Stephen Evans, Chief Executive, National Secular Society. Can you hear me?
Yes, can you hear you? Good afternoon.
Yes, please, fire away.
So back to the question of mosques. We've seen at the NSS and shared with the Charity Commission examples of rhetoric from some British mosques, including Green Lane Mosque, that could reasonably be characterised as anti-Semitic and hateful, although may not reach the criminal threshold. Given that the advancement of religion is recognised as a charitable purpose, and that charitable status brings with it state support through tax breaks and all the rest of it, should there be a review of the advancement of religion as a charitable purpose, or at least how charities are regulated when religious expression crosses that line into hate speech or extremism? And very briefly, secondly, you talked about the usefulness of stirring up of racial hatred offences. Do you think these stirring up offences could risk operating as a de facto blasphemy law if the legal distinction between race and religion becomes blurred as it perhaps does through the concept of Islamophobia?
So in answer to the second question, undoubtedly yes. I mean, if for example, any definition that was to come in relation to Islamophobia or anti-Muslim hatred was to involve, I think it's been suggested, a particular term of racialization, of course that's the risk. I don't want to say any more about the definition. I will tell you this, I was consulted by the government and I'm going to respect the confidentiality that I was given when I did that. So I won't say any more about that. In terms of the Charity Commission, I mean, please no more reviews. I think we just need effort. I mean, it's so clear to me that when people, I mean, I go into my world of counter-terrorism, I think as I mentioned, counter-terrorism police and counter-state threats police are really good at finding creative ways of dealing with threat. They don't always need, very often they don't need at all a terrorism offence in order to disrupt someone who's going to cause us harm. Let us use the tools that we currently have, and if that involves the Charity Commission having greater focus, then good.
Just looking. Yes, gentleman there, front row, last question.
Thank you very much. Jochen Bitten, I'm the UK correspondent for Germany's Die Zeit newspaper. Mr. Hall, thanks very much for your remarks. You mentioned that there's no lack of law, but a lack of resolve. And I wonder if you could give some reasons for this. Or to put the questions more precisely, could it be the case that the appeasement of Islamists has become part of Britain's both legal and political culture in the past 25 years? Thank you.
I mean, I think you'd have to ask a police officer that question. But the example that I find so striking, which I think may begin to answer the question, is that intelligence the West Midlands Police apparently had. Knowing on intelligence basis that there were people literally conspiring to take up weapons to go and attack people on the grounds of nationality ought not to have been the basis for a ban on Tel Aviv. It should have been the springboard for a criminal investigation. I can only assume that the premium on public order, if you're a police officer with a large population of, I will call them Islamists, Muslims, the premium on keeping public order means that sometimes they stay their hand and don't go where the law should take them. But I mean, I can't speculate any further than that.
I'm sorry to disappoint anyone. I think we'll all agree we've had a great turn. It's been an outstanding performance. Thank you, Jonathan, once again.